CAFOs are large-scale industrial agricultural facilities that raise animals at a high density. CAFOs are classified by the EPA based on the type and number of animals they contain and the way they discharge waste into a water supply. Discharges are regulated under the NPDES permitting program of the EPA. In the past several decades, we've witnessed a trend of CAFO expansion and increasing consolidation in meat, poultry, dairy, and egg industries. The USDA's 2017 agricultural census revealed a 14% increase in animals living in factory farms. Supporters of CAFOs herald their ability to deliver meat, milk, and eggs at low costs due to their efficient feeding and housing of animals. However, a deeper dive into the data evinces numerous harmful environmental, economic, and public health effects threatened by the expansion of factory farming.
My name is David Maraskin. I'm the Managing Director of Litigation at FarmStand, a newly formed legal nonprofit that focuses on industrial animal agriculture. Indeed, we're the only legal nonprofit in the country dedicated solely towards taking on industrial animal agriculture. When you walk down a grocery store aisle, you see all these different brands and different items. Those are really owned by a handful of companies. 4 companies control 66% of all hogs, 58% of all chicken production, 80% of all beef production. And because, again, these are concentrated companies that are then focused on maximizing their profit, they also are going to put these facilities close together. So it's not simply that you have one 8,000 head Dallas, Texas manure producing farm. You have hundreds of these farms together in a very isolated geographic community. And so what they do is that they pump these waste into massive lagoons that are then going to sit open in fields. These are typically football-sized fields of waste, which means it can blow off. And so that then is where we start to get into these tort issues, because you get blowing from the manure onto people's property, into their lungs.
In addition to manure, factories produce other animal waste that impacts local communities, including feathers, dust, and even dead animals that are piled outside the farms. Particulate matter from waste has been shown to contribute to several respiratory diseases, including chronic bronchitis and decreased lung functioning. Other emissions include ammonia from undigested compounds in manure that can irritate the respiratory tract, skin, and eyes. The odor from ammonia and rotten eggs can be so overwhelming, people refuse to go outside. Unsurprisingly, these emissions have been scientifically proven to increase the prevalence of chronic disease in neighboring communities.
And so they place these farms in where they can get the cheapest land and where they can put these impacts because of historical inequities. And so, as it may not be surprising, many of these farms are placed in historic communities of color.
One example of the correlation between the location of factory farms and low-income communities of color is the litigation against Smithfield Foods in North Carolina. A mass action of majority black plaintiffs filed over 24 nuisance suits in 2014 against a Smithfield subsidiary, Murphy Brown. The plaintiffs described being trapped in their homes by the smell and noxious fumes of Murphy Brown's industrial hog operations. Although the settlement won by plaintiffs was unknown, jury findings at trial awarded damages of nearly $550 million. Although the Smithfield litigation was ultimately successful, the trials demonstrate one potential problem with the use of tort law to address the issues of factory farms: the ability for large corporate entities to displace liability onto local farmers. Here, Murphy Brown argued that their contractors were independently responsible for the creation of excessive odor, noise, and vermin from its operations.
What's so peculiar about this is that they really own the land and they own the houses. But in order to get the contract to produce for the company, they have to build the houses to the company's specifications. Then the company owns everything else. And by everything else, I mean everything. Those chickens are never owned by the grower. They then control the feed that's given. They control the veterinary care that can be administered. All the grower can do is cull dead chickens and clean out the facility. Nonetheless, if they can hide the relationship, you often are left suing a farmer who both is not as morally responsible, but also isn't the deep pocket. Smithfield was found responsible. Smithfield was found liable. Nonetheless, it punished the farmer by canceling the contract. The equities of the suit had this other consequence of killing the livelihood of this farmer, which becomes its own set of questions. Even when you have a successful challenge, there's this really big potential for what we would characterize as blowback in the legislator to change what we know about tort law, to undo the ability to actually bring a successful suit.
For example, in the wake of the Smithfield case, North Carolina passed a right to farm statute in the Farm Act of 2018. Right to farm laws limit the ability of plaintiffs to bring suits against farms for various torts claims. Such statutes have proliferated across the rest of the country as well, demonstrating legislature's commitment to insulating farms from liability that stems from externalities imposed on nearby communities. Legislators often cite the economic importance of such operations to local communities and the U.S. food system more broadly, while simultaneously failing to see the demonstrable and disproportionate negative impact these laws have on poor communities of color around the country. By stripping away the right to sue, there is nowhere left to turn for individuals who live near large-scale farming operations besides their local legislatures, which are already in the pocket of the economic juggernauts that factory farms have become.